just wanted to let everybody know that today we are honored to have Joe Austin as our speaker today. Joe is the owner and managing attorney of the law office, Joe Austin Esquire. He brings a wealth of knowledge of business law and Indigenous policy. He earned his bachelor's in business administration and management from the University of Arizona Eller College of Management, followed by his law degree and a certificate of Indigenous People and Policy from the U of A College of Law. He further pursued a Master's of Law in International Economic Law and Policy, making him a strong advocate for Indigenous business and sovereignty. I'm going to go ahead and hand it on over to Joe. He has a long resume, but I'll go ahead and have him take it over from here.
Good morning, good afternoon to everybody out there. Thanks for the invitation, Sophia, to come back and work with the Change Labs organization again. I always have fun working with Change Labs, and some of the folks there have become very good friends and colleagues of mine. So I always appreciate the opportunity. So this workshop, this is one of my more in-demand workshops because there's so much importance to it, especially if you're a business owner, if you're an entrepreneur. At some point while you're doing business, you're going to come across contracts, whether you're going to be offering contracts or whether somebody's going to be offering you a contract, whether you're selling goods, you're selling services, you're going to need contracts. Contracts are the sword and the shield for your business, right? They help you do business. At the same time, they protect you, your business. You might be a sole proprietor too. The contracts can protect you as well. In this workshop, I'm going to try to cover these things on this list. Number one is, what is a contract, right? Some of you might have preconceived notions about what a contract is, but there's a lot of legal principles that actually go into contracts. When you go into law school, your first year of law school, you take a whole semester on contracts, where you learn about, what constitutes a contract, what are the elements of a contract, what's a breach of contract, the remedies, what makes it enforceable, not enforceable. So those are the things that I'm going to try to cover here today. Like I said, there's a lot of laws, regulations, UCC, common law principles that come into play, but I'm going to try to keep it as simple as I can. If you have questions, feel free to put it in the chat, so that way we don't forget your question and I can go back and I can, see what y'all are thinking, and any comments, stuff like that, go ahead and put it in the chat. So like I said, there's an important part of contracts. The contracts, they set forth your duties and obligations. When you're working with another party, who's going to do what, what's the scope of work, how much are you going to get paid, what are your invoicing terms. Those go into a contract. Basically, they're promises, right? Is, look, I will do this for you. I promise to do this for you if you promise to pay me something, right? That's the basis of a contract. And so when you're a business owner, an entrepreneur, like I said, one of your primary tools is going to be contracts. And I always tell people, don't discount contracts, and I would caution those who think they can go on to Google, and get one of those templates, right, that you find on Google. It's a free contract template. There's an art form to contracts. We draft contracts in my office almost on a daily basis. Contracts, they need to be molded and shaped to fit whatever transaction that you're going to enter into. Believe it or not, depending on the jurisdiction, some of those contracts don't even have to be in writing, but I always recommend put it in writing. So that way, if there's ever some kind of dispute or disagreement about, the transaction or how somebody should be paid, you have it right there in writing, the terms and conditions. So let's start with the first question. What is a contract? Well, in law school, you learn that a contract has three elements to it. There's the offer, there's the acceptance, and there's a consideration, right? The offer is that outward manifestation. It's a signal, that you want to make a deal with somebody, right? The acceptance, it's the power that you have as somebody who's being made the offer, right? You have the power to accept it. Again, it's an outward manifestation, that, hey, look, you're making me this offer and I have the power to accept it. What does that look like? Is it a signature on the line? Is it a thumbs up? Is it, a statement, yes, I accept your offer? Probably all of the above. The third element to a contract is what they call consideration. Consideration basically is the money behind it, right? It's the main thing that makes a contract enforceable. I I offer to sell you, this item in exchange for this amount of money, and you have the power to accept it. Sure, I will buy that item for this amount of money. The money itself is consideration. So every contract should have consideration behind it. Otherwise, it's not considered, no pun intended, it's not considered enforceable. So the law of contracts, like I said, when you learn about this stuff in law school, number one, there's the common law. The common law is the unwritten, unspoken law that governs contracts, right? Before we had any kind of written rules or regulations or UCC that governs, what a contract should look like, what the terms and conditions should be, all that. There's something called the common law that governed, the enforceability of contracts. And what the common law was basically, the customs and traditions between parties of how they typically negotiated a contract. And a prime example would be indigenous people, right? You think about Navajo Nation, there's a common law of contracts where under Navajo common law, a contract, is somebody coming in, making you an offer, accepting it, there's consideration, and there's a meeting of the minds under Navajo law. Now, that's not a written law anywhere. That's called the common law. Now, the written form of law that you usually see, if you're a business, at some point, you might be dealing with this kind of law. It's called the UCC, also known as the Uniform Commercial Code. So the UCC has 9 articles to it. For purposes of this discussion, we're probably only going to really have to focus on Article 2, which is sales and leases. So if you're a merchant and you're dealing with another merchant, right, business to business transactions and dealings, Article 2 would probably govern that contract and that transaction that you're working with. And so when we represent companies, and we have some clients that do federal contracting, or, they do contracting with a government, state government, or something like that, we have to always be cognizant of Article 2. Because Article 2 will govern, the enforceability of those contracts between the two merchants. So that's the basis, and I'll keep it as basic as that. In New Mexico, you can find the UCC in Chapter 55 of the New Mexico statutes. For those of you who, want to go out there and look at it, and I encourage you to do it because, you have, as a business, business goes hand in hand with the law. There's a lot of laws that govern your business, and Article 2 of the UCC is probably going to be one of them. So I would encourage you to, do some research. If you're over in New Mexico, New Mexico statutes, Chapter 55 is where you're going to find the UCC. In Navajo Nation, the UCC is codified in the Navajo Nation Code. It's going to be Title 5A. So you can familiarize yourselves, with the UCC. I think you're going to be in a better position to do business moving forward. So Article 2 is, like I said, the one that governs sales. Now, let's talk about making contracts. So if you remember, you have the main 3 elements of a contract: offer, acceptance, consideration. But there's also some other things that we have to keep in mind in addition to those. So really, these are what you would call the additional, elements. And again, you can probably see why it's so confusing. If you're in law school, you have 3 elements and then they throw another 3 on top of it. Then you have your exceptions and stuff like that. But basically, I break it down like this. We have the offer, we have the acceptance, consideration, but we also have the other 3 considerations to keep in mind. Number 1, is the contract you're making legal? Number 2, do you have the capacity to enter into that contract? And number 3, is there a meeting of the minds, right? Are both parties on the same page about what should go into that contract? Right. So not only are you dealing with, someone making you an offer, you have the power to accept it, and then there's money that underlies the contract, and that's the basis for the contract. You have to think, is this contract legal? Do both parties have the capacity, as in, are they over the age of 18? Do they understand the contracts? You might be dealing with somebody who has Alzheimer's or onset of Alzheimer's. Can they enter into a contract? Do they have that capacity? And then mutuality of the meeting of the minds, right? Is we want to make sure that what is being offered, what is being accepted, terms and conditions, everybody's on the same page, that there's nobody trying to insert provisions in there and keep things, secret. And believe it or not, I have dealt with those situations as well, where we're representing clients and they think they understand the contract, but when we go line by line, we come to find out that the other party is, submitting in different provisions, than what they discussed. So there has to be a meeting of the minds. That's what these elements mean. So let's look at some examples, right? Clear example, Sophia, I will sell you my car for $5,000 straight cash. Right? That's a clear example. That's the offer that I'm making. So she has the power to accept it. She might want to check out the car first, make sure it's not a lemon or something like that, make sure you have the capacity to enter into it, make sure it's a legal contract. It is. I'm not trying to sell her drugs or anything like that, because that would be an illegal contract, right? If I approached her and say, Sophia, I have some drugs here. Do you want to buy some? And we don't have to let anybody know about it. If she doesn't pay me, I can't sue her, right? Because that's an illegal contract. The not so clear example would be, Sophia, I will sell you my almost brand new Mercedes, which has 25 miles on it, for $10. And she's probably going to say, you're selling an almost brand new Mercedes for 10. That doesn't seem like a legitimate offer, right? Or is it? You don't know. I might just want to get rid of the Mercedes and, leave the United States and go live in Thailand, for the next 10 years. I just want to get rid of all my assets. So that's the not so clear offer. But here's another one. Sophia, I'm willing to sell you my car. And what are you willing to pay for it? Is that an offer, right? The other thing is commercial advertisements. And I think this is actually a pretty interesting field here, commercial advertisements. And here's a really interesting example. This is an actual case that happened back in 2000. It involved PepsiCo Incorporated. Basically, I don't know if y'all remember, but Pepsi used to have this advertisement on TV. It would air this commercial back in the late 90s, and it would show that, you can collect points, right? If you like Pepsi, you can buy their Pepsi products and you collect points for every purchase that you make. And Pepsi said in their ads, hey, look, if you collect 7 million Pepsi points, then we will give you an AV-8 Harrier II jump jet valued at $33.8 million. Well, you do something like that, there's always going to be somebody out there who's going to do it, right? And this guy's name was Leonard. He actually did collect 7 million Pepsi points. And he approached Pepsi and he said, hey, I saw your commercial. You have that jump jet and you wanted 7 million Pepsi points. And here you go. I have my Pepsi points. And Pepsi said, no, we were actually just making a joke. We didn't actually intend to give anybody a jet. We don't have a jet. You couldn't possibly be serious. And Leonard was, and he sued Pepsi, for a breach of contract. He said, hey, look, Pepsi made an offer. They told me if you collect these points, they will give me a jet. And I accepted by collecting those points, and the points was the consideration underlying the deal. Now, it sounds legitimate, right? And so the question was, the court had to decide, was this actually a contract? If you air a commercial and offer to give somebody something in exchange for something else, is that considered a legitimate contract? The court said it wasn't, by the way, and the court said no, because the court said no reasonable person would actually think that this was a contract, right? That Pepsi was actually making a legitimate offer. So the court, made an exception to it that, look, there's no way that there was a meeting of the minds behind it, right? There's no way that a reasonable person, would actually think that this is a contract. So because there was no meeting of the minds, so to speak, there was no contract, so it was not enforceable. So unfortunately, Leonard didn't get his jump jet. But so here's the other thing with the offer, right? You make an offer to somebody. There's this thing called rescinding a contract or revoking a contract, right? And so when you make an offer to somebody, usually you give them some time to think about whether or not they want to accept your offer. But you might change your mind and you might say, you know what, I actually want to back out. I don't want to do that, right? And I'm going to rescind my offer. Well, that's the power that you have, making an offer. You can rescind it, you can revoke it, or you can leave it open for a specific amount of time. Sophia, I want to, again, sell you my car. That's a Toyota Tacoma, and I want to get maybe 15,000 for it. I'll give you a month to think about it, right? And 30 days to be exact. After 30 days, then the offer is revoked. And so Sophia thinks about it for a bit, and 31 days pass, and she calls me up. She said, you know what, I'll accept your offer. I think 15,000 is reasonable. Sorry, offer has been rescinded. I gave you 30 days. It was open. You didn't accept it. We don't have a deal, right? So that's usually how that works. Here's another one, clear example of the acceptance. Somebody will approach me and says, Joe, I'll pay you $500 if you go downtown to that bar, Whiskey Roads, and you wear a skirt and ride the mechanical bull. And you have to stay on that bull for 5 seconds. Do you accept? And so instead of saying, yes, I accept that deal, I get up from my chair, go into my wife's closet, and I put on a dress and I start making my way downtown to Whiskey Roads, and then the bull's there, I jump on it, and there we go. I'm 5 seconds in and I jump out. I've accepted without even having to say it, I did what you wanted me to do. I am now entitled to $500. So acceptance can also be through silence. It can be through performance, right? That's another example of it. The other one, and you might be more familiar about, is your insurance policies, right? So when you have a car insurance policy, you pay for 6 months, to be covered, and then 6 months rolls around, and then your insurance company automatically renews your policy. You might be thinking, well, wait a minute, I didn't even tell them that I wanted to renew, and they renewed anyway. So is that considered acceptance? When you're dealing with policies like this, what the courts have said about it is that when you have a policy, like insurance, and it's usually customary for insurance policies to renew, you don't have to say, call up your insurance, every 6 months and say, you know what, I know it's going to renew, so I'm going to go ahead and renew it. Thumbs up, go ahead and do it. You don't have to do it. They can do it automatically, right? But you do have the power to revoke it, right? And say, call up your insurance and say, I don't want that to renew. So I'm telling you I'm revoking my consent. I don't want to be billed for the next 6 months. That's usually how this works. Another one, I'm handling a divorce case, right? I have a client and I tell the client, look, I'll represent you in the legal matter for $4,000. And during the case, a party comes along, the other party that we're going into the divorce case with, and it might be the husband. The husband, files a counterclaim against the wife, for something. And now the wife comes to me and says, I know you're handling my divorce matter, but can you also handle this additional matter? Right? We're changing the terms of the deal. And so she's making me, the offer. Now I have to figure out whether or not I'm going to accept it, to modify, the terms of our original deal when I'm representing her in one matter and for $4,000. And I might say, yeah, sure, I'll do that for $1,000. And so we accept, change the terms of the deal, right? So that's another example of it. So here's where it gets difficult, right? Somebody makes you an offer. They might send you a contract or something, and you look at it and you're thinking, okay, this looks like a good contract, but I don't like this term. I don't like this provision. And you start striking out terms and provisions, right? And then you send it back to the other party, and the other party looks at it and they're saying, well, I see that they redlined this, and I'm going to add this. I'm going to change this. And then they send it back. And so there's this back and forth that goes on between the parties, right? That's called a volley. That's the legal term behind it, and as attorneys, we deal with that all the time on behalf of clients. Somebody makes a contract, sends it to me. I'm representing a client. I go through it, I redline it, and I send it back, and I said, here's a counteroffer, right? And so when I change the terms of the deal, that becomes the counteroffer. Example, I'll sell you my Kia Optima, Sophia, for $5,000. And Sophia says, it's a little bit out of my range. How about 4,000? Well, now the power of acceptance have shifted, right? She had the power to accept it. She didn't. She changed the terms. Now she put it in my court through a counter offer, right? So that's the counter offer that she's making. Now, when you're a business, like I said, you got to be aware of the UCC, because the UCC deals with transactions between businesses, or as they call it, merchants. Right. And there's a specific way that they define what a merchant is under the UCC. It's those businesses, those entrepreneurs that have a particular set of skills, knowledge, that's specific to an industry. That's what's considered a merchant. And when they deal with other merchants, there's rules in the UCC, specifically Article 2, that will govern what that transaction is going to look like. So when we're dealing with the volley of the terms and parties are negotiating contracts, there's rules under the UCC that will govern, how that contract should look and what are the guidelines that the parties should follow. So keep that in mind. Here's an example. Navajo Times, right? We're dealing with the merchant Navajo Times, and they want to buy some paper from Dunder Mifflin. And so Navajo Times drafts up a purchase order and they send it to Dunder Mifflin and they say, we want to buy 10,000 reams of bright white paper and we will buy that at $2 per ream. Well, we have a salesman, Dwight Schrute, he looks at it. He says, okay, I'm going to fulfill this order. This is a great deal. So he sends the order to Navajo Nation. He fulfills the purchase order, and the Navajo Times looks at it and they say, wait a minute, this is not the bright white paper that we ordered. This is eggshell white. And there's a note from Dwight Schrute in there that says, hey, we are out of bright white, but I am sending you eggshell white, and this is an accommodation. Is this a deal? Well, situations like this are governed by the UCC, and the UCC would basically say, you have the power as Navajo Times to accept this as an accommodation. right? So you can say yes, or you can reject it and have your courier send everything back to Dunder Mifflin. It's been rejected. That's what the UCC governs. So let's talk about consideration. The general rule, again, is that promises, deals, contracts, whatever you want to call them, they're unenforceable unless they're supported by consideration. And consideration can be anything of value. It doesn't have to be money. It can be a promise, right? It's a promise for you to do something or to not do something, which you had a right to do. So promises to do something without consideration are considered gratuitous gifts, right? And typically, courts would not inquire into consideration of a contract, right? Most courts would stay out of that unless it's that example, between me and Sophia, where I'm trying to sell her my brand new Mercedes-Benz for $10. Then a court might step in and said, that's inadequate consideration for this item that obviously is of value. There's no way that can be considered an enforceable promise or enforceable contract. So when you promise to do something for somebody, like, hey, Sophia, you know what? I got a brand new leaf blower and I will come over to your house, this weekend and blow all the leaves and clean it up for you free of charge. There's no consideration behind it, right? So Sophia can't come around later and sue me in Navajo court and say he promised to clean up my yard with his new leaf blower. He didn't show up, so I want you to force him to come out here and blow my leaves around. Well, can't do it, right? Because there's no consideration. I offered that as a gratuitous gift to her. And it's my decision whether or not to fulfill that. Let's look at some examples here, right? Again, Sophia, I'm making you a lot of contracts today. So I'm offering to sell you my Toyota Tacoma for $15,000 and you accept and you give me a huge wad of cash. There you go. That is clearly consideration. I'm walking away with that cash. Here's a not so clear example. And this is actually a case that happened. And you read about this in law school. But there was a good Samaritan, as they called him in the case. He actually came across a son during his travels who was, I think he got into a car accident and he was on the brink of death. And the Good Samaritan found him and nursed him back to health and all that. And the father who took care of the son, he was out of town when all that was happening and he didn't know about any of this. And when the father returned, he said, you know what? I'm so glad for you saved my son's life. I promise I will pay you a certain sum of money, just for your good deeds. But unfortunately, the father never paid, right? And the Good Samaritan tried to sue the father in court and said, hey, I found his son. His son, would not be alive, today if it wasn't for me and, my actions, nursing him back to health. And the father said he was going to pay me. He didn't pay me. Well, there was no consideration behind it at the time, right? That was a gratuitous action that the Good Samaritan was performing, right? And the father had no idea that was even happening. So there was no contract there. And so these things, I'm telling you, again, these are all based off of cases that have actually happened. So you can see, the different kind of situations that the courts deal with, that this stuff actually does happen. And at some point when you're doing business, I hate to say it, but at some point, and it's very true, your business is going to get sued at some point. It just happens all the time, and it's not all the time, but every now and again. But you will come across legal issues like this. So it's important to understand what is a contract, what goes into a contract, and when is a contract not enforceable, right? And that's what we're talking about here today. And so the other consideration we talked about, legality, right? So there was cases like this that came into the courts, right? Is a contract, for prostitution considered a legal contract? It's not. Most jurisdictions, prostitution is illegal. So, offering services, in exchange for consideration, even though, all those elements are there, under public policy, under the law of the jurisdiction, this is not considered a legal contract. Not unless you're in Las Vegas, then it might be, right? So legality is also something, selling somebody drugs. You see those cases where you get drug dealers who try to enforce contracts because somebody didn't pay them for drugs. You do see that. I'm not even kidding. In our legal career, we've seen a lot of crazy things. So the other one, capacity. And so, like I mentioned, you must have the capacity to enter into a contract. Both parties must have the capacity. And typically what that means is that the courts would probably consider whether or not the person is over the age of 18. Are they an adult? Are they mentally competent? And for companies, who have agents, who might enter into contracts on behalf of the company, did they have the authorization to do so? right? So, if we're dealing with Change Labs, right? And Change Labs comes to me and they say, Joe, we want to hire you, to perform some services for us. And, you can work with Sophia to, figure out the retainer agreement and all that. I said, sure. So I contact Sophia and, I start working with her. We figure out a retainer agreement and she signs on it on the line and I sign it. And I think we have a contract. But, Jessica Stego might call me up and said, hey, where's the retainer agreement? You're supposed to work with me on it. Well, I work with Sophia. And then Jessica says, well, she doesn't have the authority to enter into contracts. That's not what our bylaws say, right? So when you're operating a business, you have to consider, does your employees have the capacity to enter into contracts on your behalf? Can they sign on those contracts? And we've seen cases like this as well, where you might have a situation where an employee, signs off on contracts and purchases a bunch of equipment, and then they take off, during the night and they take all the equipment with them. And then the company comes in the next day, the officials come in, whoever it is, business owner, where's the equipment? Well, hey, we gave it to that guy. He signed off on the contract. Well, he didn't have the authority to do that. Well, what do you do in this situation, right? Somebody didn't have the authority to enter into a contract, but they did anyway on behalf of the company, and they took the equipment and they fled into the night. It's another interesting case that that we dealt with in my law office. So let's look at the last one. So there must be a meeting of the minds, right? You have to have both parties that understand the terms and conditions that are going to go into that contract. And you have to have the intent to enter into the contract. Somebody can't just come along, after you start contract negotiations and, a month later say, just kidding, I don't want to do that contract. So there's no meeting of the minds, right? I didn't have the intent. I was just messing around. You got to make sure that both parties intend to enter into that contract and they understand the terms and conditions behind it. Like I said, that's why it's very important for you to read the contracts. When you're being offered a contract, go through it line by line. And if you don't want to do that, you might want to have an attorney take a look at it. So I encourage you to always use legal counsel. I think legal counsel can be one of your best resources that you have as a business. Make sure you're not being overcharged by some of these crazy attorneys out there. So let's move on to written contracts. So again, it depends on the jurisdiction, right? It depends on the laws. It depends on whether or not you're a business or you're a merchant dealing with another business. Does it have to be in writing? That's the question. And I always get asked that question. Should I put this contract in writing? And I will almost always say, yes, put that in writing, even though you don't have to. A lot of contracts, you don't have to. Navajo Nation is interesting because Navajo Nation is a jurisdiction that actually recognizes oral contracts. And that's where we've seen a lot of litigation because, people will have some kind of dispute down the road and say, well, we had a contract in place. And I said, well, where's the written contract? Well, we agreed orally to these terms and conditions. Well, how do you prove that? Right? If you're going to go into court and you want to sue somebody for breach of contract, but you have an oral contract, there's nothing to show the court, right? So I always say, put it down into writing, sign it, make sure everybody understands it. But like I said, Navajo Nation oral contracts, maybe a simple oral contract might be enforceable. Sophia, I'll sell you my coffee mug for $5. Sure, I will buy it. Here's $5. We have an oral contract. You don't need terms and conditions behind it. Choice of law, choice of forum, scope of work. We don't need any of that. It's a pretty simple transaction, right? So that might be a situation where you can do an oral contract. Now, some contracts are actually required to be in writing under something called the statute of frauds. And those contracts are typically contracts that cannot be performed within 1 year of the contract's formation. We might be dealing with a construction contract, right, where the construction is projected to take over 2 years. It's a project that's going to take 2 years. So obviously that's going to be over 1 year. Under statute of frauds, that has to be in writing. If you want it to be enforceable, put that in writing. For contracts that exceed $500 for sale of goods, those have to be in writing. And again, we're dealing with merchants, right? So if you're a business and let's say that you sell t-shirts and there's another company that says, hey, we want to buy $1,000 bulk sale order, of t-shirts. We want white t-shirts, we want some black t-shirts and put in a purchase order, all that kind of stuff. Well, it's over $500. That has to be in writing if you want that to be enforceable. So later on down the road, if let's say that you enter into a deal like that and it's an oral contract and, the company You might want to sue the company because they didn't pay you the $1,000. They paid you $800. So you sue them in Navajo court and you have, an oral contract. Even though Navajo Nation recognizes an oral contract, the statute of fraud says that contract, that specific one, needs to be in writing if you want it to be enforceable. Because you don't have that, you might be out of luck. So the other contracts, you think about marriage contracts. So you have antenuptials and prenuptials. We deal with this, every now and again. Those have to be in writing. Real estate contracts, executor contracts, guarantee contracts. So if you're guaranteeing something for somebody, those have to be in writing. So keep that in mind. So let's look specifically at the elements in Navajo Nation. Most of the time, regardless of the jurisdiction that you're in, New Mexico, Arizona, Utah, Colorado, the rules of contracts are probably going to be the same, right? I think all 50 states have the UCC, and that UCC is, uniform across all states. So whatever Article 2 says in New Mexico is probably going to match up to what Article 2 says in Arizona. Navajo Nation as well. Navajo Nation adopted the UCC. And the Navajo Nation Supreme Court actually decided a case in 1991 called Hood v. Bordy. And in that case, the Navajo Nation decided that a contract has these elements to it, that the parties are competent, there was a meeting of the minds, there's consideration, there's a lack of impossibility, and there's no public policy violations. So in Navajo Nation, when you're doing business on Navajo Nation and you're negotiating contracts and all that, you have to have every one of these elements in your contract. It has to be present, right? So you have to be competent. Competency would most likely mean you have to be over the age of 18. You have to be an adult. There are some situations, where children can enter into contracts. And in those situations, the courts have held that if a child is entering into a contract, then the contract is not enforceable against the child. It's actually enforceable against the parents, right? So for those of you who are parents out there, keep that in mind. If your kid is entering the contract, you might be on the hook for that contract, not your kid. So there's a competency element behind it. And we also deal with situations, where somebody might be up there in years and, they might have an early onset of Alzheimer's where they have moments that they're lucid and they're present and they're cognizant, but they have other moments, where they might not be able to remember things as well. And so there has to be competency behind it at the time that they're entering to the contract. And there, again, meeting of the minds, we already went over that. We already went over consideration, lack of impossibility. So the Navajo courts have said there can't be a contract that's impossible to fulfill, right? And so if it's some wild contract, out there where, hey, I'll pay you this amount of money if you can jump 10 feet in the air. Okay, and you try to jump 10 feet in the air and all that kind of stuff. That's not an enforceable contract because it's probably impossible for somebody to do that. The other thing is public policy violations. The Navajo courts are actually big on this, that whatever is occurring cannot violate public policy. And what that means, again, when you think about it, it would be something like, entering into a contract, where you're trying to sell somebody drugs or, it involves prostitution. Those are all public policy violations. It would not be considered an enforceable contract in Navajo Nation under this case here. So when we practice law in Navajo Nation, we deal with contracts, we're well aware of this case, Hood v. Bordy, to make sure that our clients have enforceable contracts. Navajo Nation is also an interesting jurisdiction. I know a lot of people, in this workshop do business in Navajo Nation. We're all tribal members of Navajo Nation, most of us. The Navajo courts rely heavily on Navajo common law when determining contract disputes. Not so much, like if you were to handle a breach of contract situation in the New Mexico courts. New Mexico would probably heavily rely on UCC and statutory regulations and statutory law. Navajo Nation relies heavily on common law for dispute resolution. And I'm going to illustrate what that means. The Navajo courts, basically they have district courts and they have a Supreme Court. So that's how they're structured, right? And on the trial level, you have district courts and family courts. Family courts handle family law stuff. District courts handle everything else that doesn't involve family law. And that would also include any kind of contract matters. But attached to each trial court is something called a peacemaking division. And peacemaking is an interesting dispute resolution method because it's a very informal way of resolving disputes. There was a case a while back, involving, I think it was FedEx. There was a FedEx truck that was out there who ended up I think the FedEx driver was making a delivery and tried to put the truck into park. The brake failed, and the truck unfortunately ended up running over an elderly gentleman. And so this case went into peacemaking. FedEx went into peacemaking, with the family of the gentleman who was injured, and they worked it out in peacemaking where FedEx, paid a certain amount of money, to this gentleman and his family, for all the injuries and, the trauma that was caused and stuff like that. And it was a very informal way. It's not the court system. There's a peacemaker that helps decide it. It's kind of like mediation, but peacemaking has its own methods of resolving disputes. It's a low-cost system that a lot of people use. I think the peacemaking division is a great system for us to have in Navajo Nation. It's an alternative to actually going into court and hiring an attorney and plaintiff versus defendant, and there's a judge up there. That's what you're going to find in the district courts. Peacemaking is very informal, low cost. So the other thing in Navajo Nation, they have this thing called the Choice of Law Statute, and this is under Title VII of the Navajo Nation Code, Section 204A. And what that law says is that for any cases that come into Navajo court, it's statutory law that will apply first. If not, then common law will apply. And because there's not so much statutory law on the field of contracts, you're not going to find anything that regulates contracts and Navajo statutes. That's why the courts rely heavily on Navajo common law when they're trying to resolve, disputes, involving contracts. Common law is interesting, and I just want to give a short primer on the common law, just to give you an idea of what it is in Navajo Nation. So Navajo common law encompasses interactions between humans and the natural world, and interactions between humans and beings of the natural world. Navajo common law is also called fundamental law. A lot of the common law is based off of the Navajo creation story. Your customs and traditions also go into common law. So customarily, how did Navajo people negotiate contracts, right? Way back when, in the 1800s, when Navajo people engaged in trade, with the Hopis, it was the common law that governed whether or not, that transaction was a legitimate transaction, right? Or you have somebody that grows corn and, they go to another family and they say, hey, look, we know that you have a lot of sheep and we have a lot of corn and we can trade our corn for your sheep. How would that contract look under Navajo common law? And what the Navajo courts say is that, the contract, again, entails that offer, that acceptance, and the consideration behind it. And the contract is consummated with a handshake, right? So when you shake the person's hand, that's the signal that the contract is now enforceable under the Navajo common law. Navajo word for law, behazani, this is actually an interesting thing. Behazani means, something that creates a condition. People say, why do you call it that? What kind of condition are you trying to create? Well, it's this thing called huijon. Huijon is a state of harmony. It's a state of balance. When everything is in its natural state, that is huijon. Everything is its proper place, functioning well with everything else out there, it's in huijon. The opposite is this thing called huichuan, meaning chaos, right? The things that cause chaos, that shift things from that natural state of huijon into huichuan, is what the courts call nayet. Nayet, the thing that causes the breach of contract, right? That's what it would be under, Navajo law when they're deciding contracts. Well, hey, look, these parties, they had a contract, everything was going well. Something happened where the parties are now fighting, they're in dispute, all that. What was the nayet that caused it? What was that breach of contract? In different cases, it might take the form of alcohol abuse, drug abuse, assault, battery, infidelity, theft. These are all considered nayet according to the courts. And so what the courts say is our primary purpose when we decide cases is to adhere to this principle, meaning we achieve harmony through the application of law, right? That's what the courts say, is that our primary purpose is to make sure that everybody lives in huijon. If you're in breach of contract, you're in huichuan, well, it's the court's duty to put you back in huijon, right? Put you back into balance with everything. And Navajo courts again say, we do this by applying the common law to your contractual dispute. Here's a prime example. I always give this example whenever I teach at law schools to kind of illustrate to students how the Navajo courts resolve disputes. And so we have a group of students here that are studying for a midterm, and they get together and they're hanging out and, they're drafting their outlines and they're reading their books and all that. There's always that one crazy person in the study group that says, hey, we should probably really relax and we can smoke the rainbow peyote so that we can really get deep into the material. And so they light up the joint, they pass it around. Everybody's having a good time studying, feeling relaxed, and somebody freaks out. That paranoia kicks in. They're freaking out, and they're running around everywhere. They can't breathe. People, oh no, do we call the ambulance? No, give him a shot of booze and that'll level him out. Okay, they give him a shot of booze, and pretty soon everybody's drinking and people start fighting, right? What happened here? They were in a state of huijon, right? But something caused them to go into that state of huichuan. It was this illicit substance that we call the nayet, right? And so the Navajo method looks at it like that. You were in a state of huijon, you went into huichuan. Well, now we got to put you back into huijon. How do we do that? We do that by using Ba'ani, which means the rule of law. Here's another example. This is a real case that happened back in 1996, and this is considered one of the primary cases that gets cited in contract disputes in Navajo court. And I myself had used this case, when handling breach of contract matters in Navajo courts. It's called Ben v. Burbank. And there's the citation if you want to dig it up and if you want to read it yourself. It's actually a very interesting case. This case involved two clan relatives, Tom Burbank and Lucy Ben. Basically, Lucy Ben was looking for somebody to build her a house. And she had a relative, who knew construction. He knew how to build houses. And he says, you know what? I'll build that house for you, because she approached him. Can you build my house? Yes, I'll build your house for you, right? So you have an offer, you have an acceptance, and they agreed on a certain sum of money. So you have consideration. And so, but the problem is that this was an oral agreement. There was nothing written down, but they understood what needed to be done. There was that meeting of the minds. So when Burbank built the house for Lucy Ben, later on, Lucy Ben wanted him to do additional construction, maybe add on a room or, fix some walls or do something like that. And so they entered into another oral contract. And so after Tom Burbank did that additional construction, he didn't get paid. And so he contacted Lucy Ben, his relative, and and yeah, I need you to pay me, and please, I need money to do this and that. And Lucy Ben says the thing that you always hear in Navajo, East Congo, right? East Congo, and this goes on over and over again. Pretty soon, 4.5 years passes. And so Burbank goes to an attorney and he says, look, I need to get paid for that construction. Lucy Ben did not pay me. And so the attorney says, okay, great. I'm going to go ahead and file a claim against Lucy Ben in the Chinle District Court. And it's going to be a small claim against her. The amount of money, probably justified a small claim. And so the Chinle District Court decided this case, and it said, yes, Tom Burbank is entitled to get paid by Lucy Ben. But Lucy Ben hires an attorney, and the attorney does his research, and he says, wait a minute, 4.5 years has passed. That's past the statute of limitations. And so Lucy Ben's attorney filed an appeal with the Navajo Nation Supreme Court, arguing that Lucy Ben does not have to pay Tom Burbank because the statute of limitations has passed. It's 4 years. This was brought 4.5 years later. So this went up to the Navajo Nation Supreme Court, and the Supreme Court had this question. It wasn't whether or not, the statute of limitations applied. It was more so, did the parties obtain substantial justice in the district court? That was what the court had to answer. And so what the Supreme Court said was, yes, substantial justice was obtained in the lower court. Tom Burbank is entitled to get money from Lucy Ben. So Lucy Ben, you are hereby ordered to pay Tom Burbank this amount of money. Lucy Ben's attorney says, wait a minute, why are you ignoring the statute of limitations, right? You're applying this common law principle over the statute of limitations, which is clear that you must have brought this case within 4 years. Does this sound right? And this is the case that I always throw to law students because it drives them nuts, right? They're so brainwashed to follow the law that it drives them nuts. This is not right. Statute of limitations has passed. Well, Navajo Nation operates a little bit differently. It depends. When you look at this case, those parties were in a state of huijon, right? They were clan relatives. They saw each other in the community. They shake hands. They go over to each other's houses, during the holidays, stuff like that. But something happened to shift them into a state of dispute, into the state of huichuan. It was that nayet, the non-payment by Lucy Ben. She went back on her word. She promised Tom Burbank that she would pay him for the work that he did. And she went back on those words. And so what the Supreme Court said was, well, the lower court put these parties back into Huijon because it's very clear that Tom Burbank is entitled to that money. And so when the Supreme Court was looking at this, and they're telling the attorneys, look, we had one choice. We could have applied the statute of limitations and we could have dismissed this case. But this does not resolve the issues among the parties, right? This does not lead to that Huijon Nahasli, what the court says. They said if we applied the statute of limitations and dismissed this case, well, everything's going to go off the rails if we did that. Tom Burbank, Lucy Ben, and their relatives, they're going to find each other in the parking lot. They're going to continue arguing. They're going to be at the chapter house. They're going to argue over there. Pretty soon their cousins get involved. You know how it is in Navajo. All the family get involved. Well, Lucy Ben didn't pay my uncle, Burbank and all that kind of stuff. And they're fighting in bashes. The Supreme Court says we cannot allow that to happen. So we found another way to give justice to the party who was injured, Tom Burbank. We applied the common law rather than the statutory law. We found that other way, this thing called Chihuanoti, and we applied we applied Ke, and we applied Hazajadisin. And what the court has said is when you're dealing with contracts in the Navajo Nation, there's a principle that governs those contracts called Hazajadisin, meaning that your words are sacred. When you promise to do something, you have to stick to your words. You can't go back on it because that is a violation of the Navajo common law. And so the court said that's the reason why we made the decision that we made, and we upheld the lower court decision rather than dismissing it for the statute of limitations. And so the lessons learned from Ben v. Burbank, is that Navajo justice is hajogosoke, making sure things fit together nicely. Huijon is the end goal. And so this is a prime example of applying customs and traditions, to the communities. And those traditional practices work best. And so this also led to the establishment of the peacemaking program. But that's a very good example of, a contract in Navajo Nation. And you can see the difference of how that would play out compared to, a case in New Mexico court or Arizona court, where it's just these attorneys, arguing the law. It's very clear. Most likely that case probably would have been dismissed because of the statute of limitations if you're in state court. But you can see, things operate differently in Navajo Nation. So let's talk about breach of contract, right? So now we know what a contract is. We know the elements that go into a contract. We know what makes it enforceable. So you now have an enforceable contract. Well, what happens when somebody breaches that contract? One of those parties breaches a provision in there, whether it's scope of services or payment or something like that, there's a breach. Well, believe it or not, under the law, there's two types of breaches. There's a material breach, which is kind of a major thing. And then there's a minor breach, not so big of a deal. And so, but depending on what type of breach is occurring will determine what kind of remedies are available to the non-breaching party. And so here's an example from material breach. So you have a company, you order 15 rugs, from the Navajo Arts and Crafts store for $15,000. But instead of sending you the rugs, Navajo Arts and Crafts sends you 15 bracelets valued at $1,000. Well, that's obviously a material breach because a bracelet is not a rug, right? You need a specific item and you didn't get that specific item. And so that's a material breach of the contract. The minor breach, again, let's go back to our paper example, right? Navajo Times, orders 15 reams of bright white paper from Dwight Schrute at Dunder Mifflin. But instead of 15 reams, he sends you 14 of bright white, and he sends you 1 ream of eggshell because he ran out of bright white. So you have 14 reams of bright white, you have 1 ream of eggshell. It's a minor breach. And so you might be able to say, I'll accept that 1 ream of eggshell paper, that's fine, but I'm going to pay you a lower cost for it, right? And so again, your remedies depend on what kind of breach is occurring. So when we're looking at a breach contract, when you take these cases into court, the judge will look at the following things. Number one, again, was there a valid contract? What were the duties of each party? What kind of breach occurred? And is there a defense to that breach? And what kind of damages would the non-breaching party be entitled to for whatever the breach is, right? And so as attorneys, we usually operate, within that legal defense realm is, okay, I'm representing a client who is being alleged to have been in breach of contract. Well, maybe my client might have some kind of defense to that. So what kind of defenses would justify a breach of contract? Well, one might be impossibility. Well, it was impossible for my client to fulfill that contract. It might be because of, let's say, like a hurricane comes and, just destroys the manufacturing facility. So my client wasn't able to fulfill that order. Yes, he didn't send the items on time. It was because of the hurricane, right? It was impossible to do it. The other thing, it was impractical, right? Is, well, my client was having to ship items and goods from New York all the way to Los Angeles, and you expected him to do that in 6 hours. It's impractical to do something like that. So you have to think about those kind of things. Maybe there was some fraud or duress involved in the contract. Well, hey, look, if you don't fulfill this contract within this specific amount of time, then we're never going to do business with you ever again, right? And so your business is kind of, needing the funds. And so you try to fulfill that contract. Well, you weren't able to fulfill it on time. They say you're in breach of contract. You get sued. There might be some fraud or duress elements behind that. Or want of consideration, right? Or in the legal field, we call it want of consideration, or also there's a lack of consideration behind it. Those would be a defense to the breach of contract. For want of consideration, that would be something like, you have a contract with another party and let's say you're selling paper again, right? There's a want of consideration behind it, that there's not sufficient funds available to pay for your order. So you're not able to ship them the full amount of paper because they can't afford the full amount. There's a want of consideration. So those would be the defenses to a contract. So damages. So let's assume that you do have a breach of contract and the court says, okay, great, you are entitled to damages, you're entitled to relief, you're entitled to remedies. Well, what do those look like? Damages, the legal term, refers to the sum of money that's imposed on the other party for breaching a duty or violating a right of another person. And so the types of damages that are available in breach of contract cases, we might be talking about money damages, incidental damages, reliance damages, punitive damages, which are very rarely imposed. The other remedy would be specific performance and attorney's fees, right? So if you have a case where you're suing a company because they breached the contract, not only do you want money damages, well, you might want reliance damages, right? Because somebody put in an order for 15 reams of paper and you were preparing the order, and you get all the boxes set, you get all the reams in there, all that kind of stuff. You ordered more paper from another company, your supplier. All that is reliance damages, right? Is you spent money, time, and resources trying to prepare that order for shipment to your customer that's going to buy it, and they canceled on you. So now you have reliance damages. We did all this stuff to prepare for it, so you're entitled to reliance damages. Attorney's fees, right? If you're the prevailing party in a case, the Navajo courts have actually said that for breach of contracts cases, you are entitled to award attorney's fees. Okay, so at this point, I think I will take time to answer any questions, and then I can go on to some examples here that I have for contracts. If y'all have any questions, feel free to throw them out there. I don't have my chat up, so I will bring that up. Okay. Shawnee said, can this be applied to politicians that don't keep their promises? That's a good question. It probably depends on the promise. It might. Who knows? I don't really represent politicians, so I don't really sue politicians either, unfortunately. Are there any questions about the contracts here, elements, breach, damages, anything like that? Feel free to unmute yourself if you have questions. Okay.
Hi, this is Darlene. I really enjoy hearing how the courts, and I had never thought of this, and hopefully I will never have to apply it and be in court, but I enter into a lot of contracts with other tribes. Normally it just says I will settle in their tribal court. Are you familiar with like other tribes that have that special consideration to their traditional ways or their culture that, we all assume it's a similar process of law and similar court order, but when we talk about the traditional aspects, those values that are sought rather than what's just in the law books, are you familiar with other courts that do that?
Yeah. So, I mean, obviously, every tribal court is different. What I'm teaching you here with the Navajo courts, the Navajo court system is interesting because it's so well developed in the case law, just because of how large the Navajo Nation is. They have reporters that keep track of all the cases that are decided by the Supreme Court, like Ben v. Burbank and Hood v. Bordy, all that stuff. They have a well-developed case law system in Navajo Nation. And so you're able to kind of do that research as an attorney to figure out what the common law is. But you might be dealing with a tribe, like some of the smaller tribes that don't have those kind of resources, and they don't have well-developed statutes either, but they do have customs and traditions that come into play. It depends on the court, but yes, the Pueblos are a very prime example that, they do a lot of their proceedings in the language, their traditional language, and they apply customs and traditions. So there are a lot of constitutions that tribes have, and even statutes that say that customs and traditions would be applied when it's appropriate in a case. If there's a common law principle that will be used, it must be used in that tribal court. So that's kind of the catch-all provision. But yes, there is different tribal courts out there who would use their own customs and traditions to probably decide the contracts. But as an attorney, it's kind of your job to figure out what those customs and traditions are, which is kind of difficult if you're not a member of that tribe and not familiar. So you end up consulting with some of the medicine people, some of the elders, to figure out what are the common law principles that can be argued, in a case. So, and some of the judges take it on themselves to use their own traditional knowledge to figure out, what laws would be applied. So, but there's also tribes, I would say, like, I used to be a prosecutor for the Pasquayaki tribe. They have a very well-developed court system that looks very much like a state court, and it operates very much like a state court. It was very impressive to see, those proceedings and how well developed their statutes were and their court rules and stuff like that. And a lot of tribes, what they do is they adopt a state law. So you have some tribes that will use decisions regarding breach of contract that come from like the Fifth Circuit, the Ninth Circuit, 10th Circuit, or they might look at, other states like South Dakota. I used to practice in Flange Santee Sioux tribe in South Dakota, and they relied heavily on state law. So whenever you have a breach of contract, the judge would use, case law from the South Dakota courts to decide that kind of issue, or they might use that as a persuasive authority. So it all depends, but yes, that's kind of the way that it would play out. Any other questions here?
I have a question. This is Danae. Can you hear me?
Yeah.
Okay. Just wondering who is, I guess, allowed to bring a suit or to engage in, maybe not engage in contracts, but who's able to apply Navajo law? Is it just businesses located on the Navajo Nation? Do they have to be registered? Or what if it's an off Navajo business and they need to bring suit against somebody on Navajo? How does that go?
So what you're talking about is jurisdiction, whether or not the court has jurisdiction over that party, and that's personal jurisdiction. So typically with the court, they have different cases that talk about this, who's subject to the jurisdiction of the Navajo courts. If you're doing business, let's say that you're located in Gallup, and a lot of your customers, you engage in business on Navajo Nation and Window-Rock, and you negotiate business transactions there or something like that. Well, there's a nexus, what the courts would say. There's that connection that you have to Navajo Nation where you're dealing with Navajo people as your customers. That would probably give the court's jurisdiction over you, if something were to happen where a customer sues you and they sue you in Navajo court would probably say that they have jurisdiction over you because of that nexus. The other thing would be if you have a contract where you sign it and, you're located off the reservation, and it says, and I think this is what Darlene was talking about, when you do business with tribes, there's always that provision that's a choice of law, choice of forum that says this contract, if any disputes arising in this contract, will be decided in Navajo court in accordance with Navajo law. And so there's choice of law, choice of forum that would also, subject you to the jurisdiction of the Navajo courts.
Can you, just a follow-up question, sorry, that's my dog. But when you talk about jurisdiction, so for instance, the general contract that I have for my clients that I give, because I'm based in New Mexico, Farmington, New Mexico, it says this contract will be enforced under the state or laws of New Mexico. Is it common or to include like different jurisdictions, or do you just have to stick with one jurisdiction?
Typically you would have one jurisdiction, but I have seen contracts where, and that's where lawyers fight all the time is, if you're representing clients in different states, different jurisdictions, everybody wants to have their jurisdiction be the choice of forum or choice of law that's going to apply. What some people might do is says, any disputes, regarding this subject matter will go into this court, this law will apply,
Mm,
for all of their disputes that will go in this court, something like that.
okay.
I've seen that happen too. Usually it's better just to have one jurisdiction for everything.
Okay.
But I've even had people ask, can we do like a New Mexico court, but they're going to apply Navajo law? Well, there are rules that the courts have about that. It's figuring out how to apply laws of a different jurisdiction. There are some courts that will do that, but you don't want to put, that on a judge where, the judge is not a member of Navajo Nation, doesn't know customs traditions and applying Navajo law. That's just not a situation that you want to put yourself in or your clients, so.
Okay. Thank you.
Yep. Any other questions before we move on here?
I got a question. I do contracts, whether it be in Utah, New Mexico, Arizona, on off the res. Just thought about, would it be wise for me to say like I have a client that's based in Flagstaff, would it be wise to rather in my contract saying things are being done in Navajo Nation law under Navajo Nation courts to do it in Arizona law? And whether it be for Utah or New Mexico, whatever, and just keep Navajo Nation contracts under Navajo Nation court systems or what? Because no states, well, most likely, I guess clients wouldn't even have to answer to a Navajo Nation summons or whatever to come to court. You know what I mean? The whole jurisdiction issues. So if you had a dispute.
Right.
So would it be wise for me to like do my contracts per wherever they're located according to like state law or tribal law?
I mean, it's really up to the business. Usually what the considerations that some of the business think about is, wherever you're located is typically where the jurisdiction that you would want those laws to apply, because it's easier to defend or prosecute a case that's nearest to you, because that's where the evidence and witnesses and all that stuff is, and that jurisdiction is going to be familiar, with your business if you're registered there, as a corporation, LLC, all that kind of stuff, you want to have that jurisdiction. So that's for benefit of you, not so much your customers. Now, if you're worried about, and this is a big issue that we see all the time, if you have a customer, let's say that you're on Navajo Nation and it says Navajo courts, Navajo law applies, and you have a client or a customer that's located in Phoenix or Tucson or something like that, hours away, and there's a breach of contract and you sue them in Navajo court, now they have to defend, in a court that's hours away. And the first thing that they always say is, well, they have no jurisdiction over me because I'm not a member of Navajo Nation. Well, you signed a contract that says that you will go into Navajo court. So usually what happens in those situations is, as the attorneys that's representing your business, we proceed with the case, whether or not they want to partake in that case or not. We're still going to proceed with the case, and you're going to get a default judgment. And if they don't want to pay that judgment, then we go and we get that recognized in state court. So Arizona courts will recognize a Navajo court judgment and say, okay, well, you didn't participate in that case, and now there's a state court order against them. So that's usually the way that would play out.
Okay.
Not all the time.
That makes complete sense now. Thank you. Thank you for clarifying that.
Yeah, absolutely. We have Arlene.
Hi, Joseph. Good afternoon. I just have a question between, I am pretty sure for a contract would be treated in the same way under Navajo common law. My question is, if a non-native is coming on the reservation to operate a business, are they adhere to the local Navajo Nation law, or do they still have their state laws that apply to them doing business on the reservation? That is my question.
That's a good question. There was actually a court case back in 1953 that was rendered by the United States Supreme Court. It was called Williams v. Lee, where they had a Indian trader who was non-Indian doing business, he had a general store on Navajo Nation, and a lot of his customers were Navajo. And the Navajo folks that did business with him didn't pay off their tab that they owed him. And so what he did is he tried to sue them in state court, because he said, well, I'm non-Indian, Navajo laws don't apply to me, and I can take this into state court. And that case went all the way up to the Supreme Court. What the Supreme Court said is that when you're doing business on Navajo Nation, you're subjected to Navajo law. And that case, any kind of matters that arise during your transactions is subject to going into Navajo court, where Navajo law would apply. And Williams v. Lee is one of the most landmark cases in federal Indian law governing jurisdiction, what we're talking about, right? So who can be called into a tribal court. So that was a very important case that came out of Navajo Nation. The other one is it's USB Montana. And that case also rendered by the Supreme Court says that when you enter into what they call consensual dealings with Native people on a reservation, then you are subject to that jurisdiction, the laws and the courts and stuff like that. So those consensual dealings, that again, engaging in contracts and all that kind of stuff. So good question. We got a couple more minutes here. Any last minute questions? Thank you everybody for your time. I appreciate it.
Thank you, everybody, for joining, and thank you, Joe, for going over a very important topic that a lot of us kind of don't think about when we decide to start doing business is contracts.
Yeah,
I'm
I'm gonna put my email in the chat. So for those of you who have businesses and are interested in, you might want a contract to be drafted or reviewed, my office, we do that stuff on a daily basis pretty much. So feel free to go ahead and contact me with any kind of questions. I also have an office number I'll put in here. We do offer free 20-minute consultations, and I do have a website that you can visit as well. And then I think Sophia is going to go ahead or Raquel's going to put this on there. So visit me at navaholawyer.com. My email, jaustin@austinlawfirm.org, and my office number, 520-302-9990.